You can't practice if you don't have permission. There are a lot of different scenarios that present themselves when we're talking about an attorney practicing unauthorized. Physical presence doesn't always equate to continuous and systematic presence. The presence could be otherwise. It could be through electronic means. It could be through a digital presence. Artificial intelligence is going to affect the way we administer 5.5 moving forward. AI could dramatically change the landscape of what is considered unauthorized practice.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Scott Kozlov. Scott Kozlov is currently the Chief Ethics Officer and Legal Counsel for Cook County Clerk's Office, where he oversees the ethics and compliance efforts, policy enforcement, and investigations of statutory and ordinance violations, among other legal matters. From 2000 to 2020, he was counsel with the Illinois Attorney Registration and Disciplinary Commission, the ARDC, investigating and prosecuting hundreds of attorney misconduct matters, assisting in drafting Supreme Court rule amendments, presenting at attorney ethics seminars, and participating in public outreach programs. The webinar that you're about to watch will be approximately 60 minutes, and once that is complete, Scott will be joining us for a live Q&A. So if you have any questions that come up during the webinar that you'd like him to answer at the end, please submit those by clicking the Q&A button in the control panel at the bottom of your screen and submitting them there. Now, without further ado, here is Scott to discuss Rule 5.5 Demystified, what every new lawyer needs to know to practice ethically.
Welcome to Rule 5.5 Demystified, what every lawyer needs to know to practice ethically. My name is Scott Kozlov, and I'm the Chief Ethics Officer and Legal Counsel for the Cook County Clerk's Office. I'm also an adjunct professor at the Loyola University School of Law, and I am the chair of the American Bar Association's American Bar Association's Continuing Legal Education Committee, as well as the Chicago Bar Association's Unauthorized Practice Multidisciplinary Practice Committee. Finally, I also chair the Illinois State Bar Association's Task Force on the Unauthorized Practice of Law. Today, what we're going to do is talk about Rule 5.5 and its application. I've set out today an agenda for today's discussion, and what I'm going to do is try to summarize the rule for you. I'm going to try and make it a little bit easier to understand the application of the rule by breaking it down. Then what we're going to do is analyze each subparagraph of the rule and give some examples, some case precedent that helps you understand the application of the rule. During this process, we're also going to discuss the meaning of some terms of art that are included in the rule. And finally, we're going to discuss the future of Rule 5.5. What does the future hold for this rule? We're going to talk about some proposals that have already been made for changes to the language of the rule. And briefly, I'm going to mention, the implications for artificial intelligence and how that might affect the application of Rule 5.5. So, when it comes to Rule 5.5, there are many clauses and subparts to the rule, but I think it's easier to conceptualize the rule if you break it down into a few categories. I like to think of Rule 5.5 as being made up as three basic subparts or components. I would include in the first subpart of Rule 5.5 the paragraphs in A and B within Rule 5.5. Those subparagraphs basically prohibit engaging or assisting in the unauthorized practice of law, unethically holding oneself out as being authorized when an attorney does not have that authority, and establishing a continuous or systematic presence in a jurisdiction without authority to do so. The second basic component of Rule 5.5, as I break it down, would encompass paragraph C. When you look at subparagraph C, It basically contains some broad exceptions to the general rule. Paragraph C includes some safe harbors that allow for the temporary or limited practice in certain circumstances. And finally, when it comes to Rule 5.5, I think it's easy to set aside as the last portion paragraphs D and E. When you look at subparagraphs D and E, those sections apply specifically some components that relate to house counsel. When we're talking about house counsel or corporate counsel, we're talking about people that could be U.S. attorneys or foreign attorneys. And that part of Rule 5.5 allows for the continuous or systematic presence of an attorney that doesn't otherwise have permission to practice in a jurisdiction. If you think of the rule in these three basic subparts, the analysis becomes a bit more manageable when you're trying to conceptualize how to apply the rule. So, in my experience, which is primarily in Illinois, the part of the rule that is most frequently charged by disciplinary counsel is subparagraph A. Subparagraph A of Rule 5.5 in the Rules of Professional Conduct is the section that lays out the general principle. This rule says a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. We're going to break that language down further, but it's important to know that this is the concept that is violated when an attorney practices without authority. This is the concept that is charged when bar counsel or disciplinary prosecutors decide that somebody has engaged in conduct that would be against the rules of the regulation in that profession. So the basic concept is don't practice in a jurisdiction where you don't have authority or assist another in doing so. But let's dig down. What does that mean? So 5.5A can be used in a lot of different ways. 5.5A is the premise that you can't practice if you don't have permission. How does an attorney practice when they don't have permission? There are a lot of different scenarios that present themselves when we're talking about an attorney practicing unauthorized. An attorney can lack authorization for many different reasons. So, we're talking about things like an attorney lacking authorization because they've been removed from the master roll of licensed attorneys in a state. How do you get removed from the master roll of licensed attorneys? You fail to register, or you fail to complete your continuing legal education requirements. So this doesn't necessarily entail cross-border practice. So you're talking about attorneys that are practicing in a particular jurisdiction, they just fail to register. And when you fail to register, your name is removed from the roll of people that are authorized to practice, and your continued practice in a jurisdiction is thus a violation of 5.5A. This can be because you didn't meet your continuing legal education requirements, because you failed to register. It can also be because you registered as a retired attorney or you registered as inactive. If you're practicing multiple jurisdictions and you decide, I don't need to register as active in Illinois because I'm not going to be focusing my practice in Illinois. Even though I'm admitted there, I'm going to concentrate my practice in Arizona or Indiana or Missouri. So if you register as inactive in Illinois, then your practice thereafter in the state is unauthorized. There are some other iterations that I should mention. The simple kind of unauthorized practice that prosecutors see on a regular basis could entail an attorney that has been disciplined, an attorney that has been suspended for engaging in misconduct. Once an attorney becomes suspended, then the continued practice of law in that jurisdiction would violate 5.5A. Similarly, there are some jurisdictions that would say that even if you're disbarred, your continued practice after disbarment would be a 5.5 violation. Seems kind of silly, but there are jurisdictions that double disbar attorneys. So depending on the state in which you're practicing, disbarment could lead to an additional 5.5 charge. In most states where that occurs, you're talking about criminal conduct or contempt of court, where an attorney practices after being disbarred, their authorization is completely removed and they're engaging in criminal conduct. Depending on the jurisdiction, you need to know the rules where you're practicing. So those are the simple kinds of practice under 5.5A that would amount to a UPL charge. There are additional ways that attorneys can be charged with a 5.5A violation. Where in-state attorneys are practicing within that jurisdiction, but they're handling matters that pertain to another jurisdiction that overlaps with the state, they could be charged with unauthorized practice. What am I talking about? Sounds kind of confusing. Sometimes the federal jurisdiction overlaps with the state jurisdiction. For instance, in Illinois, we have the U.S. District Court for the Northern District of Illinois. And attorneys may be admitted to practice and authorized to practice in the state of Illinois, but they've never sought admission in the federal court. When that U.S. District Court for the Northern District of Illinois learns that an attorney has practiced before the bench in their jurisdiction, it doesn't matter that the attorney was admitted in the state of Illinois. There's a separate admission process for the federal district court. And when the attorney has not been admitted in that federal district, they could be engaging in the unauthorized practice. Now, there might be tiered discipline for that situation. There might be action taken by the federal district court according to its rules of professional conduct, but the attorney is still an Illinois attorney. So in that circumstance, the state jurisdiction would likely also prosecute the attorney for a violation of 5.5A under the state rules. So if you're practicing in a federal jurisdiction or some overlapping jurisdiction, even though you're admitted within a state, you could be prosecuted for a violation of 5.5A for violating that other jurisdiction's rules. Those are numerous and many. It could involve tribal courts for Indian reservations. It could involve practice before the federal circuit court, the appeals courts of the federal judiciary. It could involve practice before the United States Patent and Trademark Office. There are a lot of different jurisdictions that require admission, and unauthorized practice could fall into that category. And lastly, I should mention that 5.5A violations sometimes entail cross-border practice. Sometimes we're talking about a Minnesota attorney practicing in Illinois without authorization. That kind of situation could potentially lead to disciplinary charges under 5.5A, although in this instance, I think it's really important to mention that there are exceptions that might apply. We're going to talk about those exceptions moving forward, but those exceptions fall under a different portion of 5.5. So the general principle is you can't do it. There might be an exception elsewhere in 5.5 that you should know about. I'm going to talk about those things in a few moments. So let's cover a few cases or a couple cases where I've actually charged 5.5A violations. In Illinois, this can be an outside attorney, an attorney from a different state jurisdiction practicing in Illinois. One such example of that kind of conduct is the Jeanette Conrad case, which is listed on this slide. In this matter, a Kentucky attorney handled Illinois horse racing matters in the state without authorization. During the proceedings, the attorney held themselves out as a lawyer, portrayed to the tribunal that was handling those cases or deciding those cases that they were authorized to practice, and handled the case without clarification. In that instance, the state of Illinois found, the Illinois Supreme Court found that the attorney had engaged in a violation of 5.5A and suspended the attorney for 6 months and until further order of court. That was essentially an indefinite suspension requiring a petition for reinstatement before that person could ever practice again. I often get the question, well, why on earth would an Illinois Supreme Court be interested in a Kentucky attorney that was practicing in Illinois? Well, the answer is that Miss Conrad was holding herself out to Illinois residents as being authorized to practice, and in that circumstance, her practice in Illinois warranted discipline. There is a system for imposing reciprocal discipline imposed by states for other jurisdictions' attorneys. So the ABA maintains a database that all disciplinary prosecutors are aware of, and where a Kentucky attorney is disciplined in the state of Illinois, the result is generally that Kentucky attorney will be reciprocally disciplined in their home jurisdiction when they're suspended or disbarred in Illinois. So by taking action against Miss Conrad, the reciprocal discipline would likely occur against Miss Conrad in her home state of licensure after being disciplined in the state of Illinois. So there is a rhyme and reason to the matter when an attorney from out of state is disciplined in another jurisdiction. Another example of a 5.5A charge that was leveled against an attorney in the state of Illinois is the Maurice Salem case. In that case, a New York attorney handled civil matters for Illinois clients and engaged in dishonesty in Illinois and was ultimately suspended for 90 days and until further order of the court. In this case, very interesting factual situation was presented. Mr. Salem had applied for admission before the Illinois bar, had sought permission to be generally admitted before the Illinois Board of Bar Admissions, and was denied that permission. Mr. Salem proceeded after that denial to represent people in the state of Illinois. He did so on a pro hoc vice basis, where the system has since been amended, but at that time, the judges that granted pro hoc vice admission weren't aware, and Mr. Salem did not disclose that he had sought and failed to obtain admission in the state of Illinois. Very, very interesting case. And ultimately, it was decided by a Supreme Court order that doesn't really clarify the basis of the findings. The case went up through a couple administrative procedures, first before a hearing board and then subsequently before the Administrative Review Board of the Illinois State Attorney Registration Disciplinary Commission procedures. And the result was simply a censure. But when it got to the court said, no, this is something that was egregious and warrants an indefinite suspension. So I thought it was a very interesting case to share. You can find these cases on the Illinois ARDC website, which is iardc.org. That's iardc.org. There's a keyword search database that you can access to look up the cases, but you do have the case numbers there on the slide, so you can find further details if you want them. So, an interesting issue with respect to 5.5 is, when there is a cross-border type issue involved, what's the procedure to be followed? Which state should be prosecuting these cases? It can be either. It can be either the home state where the attorney is licensed and admitted that brings a disciplinary case for the conduct that occurs elsewhere, or it could be the prosecution engaged in by the state where the conduct occurred. How is this possible? There's a tie-in here to Model Rule 8.5. in the rules of professional conduct. ABA Model Rule 8.5 says that lawyers can be prosecuted where admitted, regardless of where the conduct occurred. But the rule also says that lawyers who are not admitted to a jurisdiction submit themselves to that jurisdiction's authority by practicing there. So the possibility is that either jurisdiction, either the home state or the jurisdiction where the conduct occurred, can bring a disciplinary action against an attorney. That was the example in both the Salem case as well as the Conrad matter that I presented earlier. But which state would be best? Which state actually chooses to take the case? It varies by jurisdiction. There's no clear formula to present that would give you the answer to that question. It's pretty clear that when conduct occurs in a particular state or jurisdiction, that the witnesses and evidence are located in that jurisdiction. So that was the reason why the Conrad and Salem cases were charged in Illinois. It would be very difficult. It would be impractical to expect witnesses to travel to another jurisdiction where an attorney is actually admitted for purposes of a disciplinary action. Can it happen? Has it happened? Yes. Yes, those things have occurred, and home states do prosecute attorneys even when the conduct occurs elsewhere. But in those cases that I presented, Illinois decided that, at least the Attorney Registration Disciplinary Commission decided that it would be best to bring those cases where the conduct occurred. The evidence was there, the tribunals were there, the witnesses were there, and all the evidence could be presented pretty easily in Illinois. So that's why we decided to prosecute in that particular situation or those particular situations. So we've talked about reasons why 5.5a is prosecuted based on the attorney's conduct. Where an attorney lacks authorization to practice and does so, that first part of 5.5a is implicated, and disciplinary prosecutors charge on that basis. But sometimes the conduct is not the attorney that actually, is engaging in UPL. The conduct is that the attorney is assisting somebody else in doing so. So that second clause in 5.5a, or assist another in doing so, is key to the charging of 5.5a in certain circumstances. Just like the first part, there are many iterations that result in an attorney assisting another in prosecuting unauthorized. How does that happen? It happens when an attorney delegates work to a paralegal and doesn't supervise the paralegal's work, that the paralegal is just handling matters without supervision. The paralegal is engaged in the unauthorized practice of law, and the attorney is facilitating that or enabling that. So in those circumstances, assisting another in doing so would be implicated, and 5.5a is charged. Usually it's not the simple attorney-paralegal relationship that results in these kinds of charges. Usually we're talking about the attorney working with third parties. This is the situation where an attorney is engaged with estate planning consultants or financial advisors that sign clients up to fee agreements and engage the clients for legal work, and then the lawyer actually does some of the legal work. It's not possible for a non-attorney to have the knowledge or skill required to decide what services the client needs in those circumstances. So simply signing a client up to a legal fee agreement without first having vetted the matter with an attorney can be the unauthorized practice of law. If I'm the financial planner that's hosting seminars for potential clients, I'm trying to drum up business for my financial planning enterprise, and I'm answering questions about estate planning, the need for wills or trusts. And clients come up to me and say, I've listened to your presentation and I really think I need a trust. What do you think? And the financial planner says, yeah, you absolutely do need a trust. Here's what it would entail and here's what the cost would be. That financial planner is making a legal determination. That financial planner is deciding that these potential clients need a trust. Now, even if an attorney has given some blank, fee agreements to this financial advisor to present to potential clients, the financial planner is not competent to make the decision as to whether or not a trust is needed or how much money is going to be required, to pay for the services that these potential clients need. So that would be the unauthorized practice of law. The similar type situations arise when we're talking about loan modification services, or we're talking about real estate agents that are handling closings on behalf of attorneys. Depending on the law of the jurisdiction in which you're practicing, some of those services might involve the unauthorized practice of law. It's clear that certain services are authorized to be performed by loan modification services or real estate agents. Real estate agents commonly sign or enter into the contracts on behalf of clients with buyers and sellers. But when they take that effort a little bit too far, when they start, advising the buyers or sellers as to their legal rights and the ramifications of certain actions, when they start modifying the contract based on the statements of clients and their desires and explaining what the ramifications of those changes would be, some of those actions go too far. And those kinds of situations result in the unauthorized practice. Now, how could an attorney assist somebody in those circumstances? Well, in the case of the loan modification services, there are statutes that forbid loan modification service providers from taking fees up front. And attorneys then partner with these people to allow legal fee retainers to be taken up front, and the services are still performed by the loan modification service provider. So the attorney is partnering with that person to enable that non-attorney to do something that they could not otherwise do. That could be charged as the unauthorized practice of law. Similarly, if the attorney on a real estate closing is delegating the services to explain the contract and sit through the closing to the agent, then the attorney might be engaging in the unauthorized practice of law by assisting the real estate agent in doing so. So those are some of the examples that I can think of that would allow for the charge of 5.5A to be used for assisting another in doing so. There's one other instance that I should mention that, again, requires qualification, and that's that out-of-state attorneys can be assisted by an attorney in a jurisdiction in engaging in the unauthorized practice of law. If I'm the Minnesota attorney and I have an Illinois attorney that's enabling me to engage in the unauthorized practice of law, that second portion of 5.5A could be implicated, assisting another in doing so. Now, again, just like I mentioned with the first part of 5.5A, that type of charge is qualified by some of the exceptions that we're still going to talk about. So, hold on, we're going to get to those issues. I thought I would give you a couple examples of cases that were brought against attorneys for assisting another in engaging in the unauthorized practice of law. The two cases on the screen that you're looking at now, Jeffrey John Ailman and Thomas George Macy, are two cases that were charged in Illinois when these two attorneys assisted others, non-attorneys, with engaging in the unauthorized practice of law. These two attorneys ran a debt resolution company, and they were a two-attorney firm that was handling high-volume debt resolution matters, and it just didn't seem practical that they were able to accomplish all this work. And the way they were doing it was they contracted with non-attorney agents to actually sign up clients and perform legal work. What legal work were the non-attorneys performing? They were negotiating the resolution of the claims pending against the clients. They were settling the claims. The attorneys had very little involvement in those matters unless there was a bankruptcy filed or there was some specific legal question that needed to be answered. The attorneys were not involved. The cases were being settled by these non-attorneys, even though the attorneys were reaping the rewards. It was quite profitable, and this two-attorney firm got a little greedy, and they were ultimately disciplined for this kind of activity. Both attorneys were suspended for 2 years. This just gives you an example of attorneys going too far in using the services of non-attorneys, assisting others in engaging in the unauthorized practice of law. Okay, so let's move on to paragraph B of 5.5. Paragraph B is the provision that prohibits attorneys from engaging in a systematic and continuous presence in a jurisdiction or holding themselves out as being admitted when they don't have authority to do so. A lawyer who's not admitted to practice in a jurisdiction shall not establish an office or other systematic and continuous presence for the practice of law and cannot hold themselves out to the public or otherwise represent to the public that they're admitted. This part of 5.5 requires some explanation. So what does a continuous and systematic presence mean? What are we talking about? We're generally talking about setting up shop. You're hanging a shingle in a jurisdiction and making it appear as if you're authorized to practice there. It could mean something more nefarious than that, but sometimes it's as simple as just, I've set up shop. I have an office in Illinois and I'm not authorized to practice in Illinois. There are some states that take this further. The interpretation of 5.5b depends on the jurisdiction in which you're practicing. I've listed a Maine ethics opinion from 2005 that says, having a website that holds you out as authorized to practice in that state amounts to a violation of 5.5b. There's also a case from California, the Bierbauer case from 1998, which goes pretty far back. And it states that you can practice in that state simply by using phone, fax, computer, or other equipment, even if you're not physically present in the state. So physical presence doesn't always equate to continuous and systematic presence. The presence could be otherwise. It could be through electronic means. It could be through a digital presence. It doesn't necessarily mean you have to be physically present in the state to violate 5.5b. The trend is for states, because of the portability of information and mobility of people these days, the ease of transfer between state borders, the trend has become that most states say you can practice in a state as long as you're not applying the law of the jurisdiction of that state. So as long as I'm not handling, Illinois matters, I can practice within the borders of Illinois without violating 5.5b. That's the trend, but again, it's jurisdiction specific. You got to know what your jurisdiction's law allows. Missouri is different in that respect, and it goes against the grain with respect to that kind of finding. So you got to know what your jurisdiction says before you engage in practicing law before that, within that particular jurisdiction. I think we should also talk for a little bit about how does an attorney hold himself or herself out as being admitted in a jurisdiction. Just listing on a sign, Jane Doe, attorney at law, without disclaimer, without any clarification, if you're not admitted to practice in Illinois and you're Jane Doe and you list that sign, on your office window, then you're engaging in the unauthorized practice of law by holding yourself out as being admitted into the state. What would passersby think if they read that sign? If I'm walking, through a hallway and I see the sign, Jane Doe, attorney at law, I'm in Illinois, there's no clarifying information on that sign, I think that Jane Doe is admitted to practice law in Illinois. So in that respect, 5.5b would be violated. Now, there are some exceptions to that rule as well. Disclaimers sometimes clarify an attorney's authorization to practice and allow an attorney to do legal work within a state where they might not otherwise be allowed to do it. We're going to get to some of those exceptions, but just to give you an idea of what I'm talking about, we could talk about it later as I go through the other provisions of 5.5. We're talking about somebody who's doing immigration work, federal practice, and their sign says admitted only in California, even though the office is located in Illinois, practicing exclusively immigration law. So that's the kind of situation that the disclaimer might allow. Now, again, you got to know the law of the jurisdiction which you're practicing, but that's one example where the disclaimer might allow that attorney to do things that they might not otherwise be allowed to do. So I'm going to move on now. We've talked about holding yourself out and establishing a continuous and systematic presence under 5.5b. Let's go to 5.5c. 5.5c is the section that relaxes the prohibitions on unauthorized practice to allow temporary and limited practice in certain circumstances. It contains 4 safe harbors where temporary practice is admitted. In all of those situations, with respect to every one of the 4 safe harbors, the attorney must not be suspended or disbarred in any jurisdiction, and the specific representation being handled must be temporary or limited in nature. Again, what is temporary? There is no bright line test. You got to know the law of the jurisdiction which you're practicing. It's open to jurisdictional interpretation. The model rules are just a template. When we're talking about model rule 5.5c, it's a template for each of the states to modify as it sees fit and to interpret as it sees fit. So there are different interpretations in different states and within the various jurisdictions, whether federal or state or otherwise. So you got to know how that jurisdiction where you're practicing interprets the rule. I've given you a case cite here, Gould versus Florida Bar, which is from 2007, that said that a New York attorney's practice was not temporary in Florida when the attorney actually resided in Florida. It found that the situation resulted in a more permanent type situation and therefore was not temporary. But let's move on and talk about the 4 safe harbors under 5.5c. What are they? When are attorneys allowed to engage in temporary or limited practice when they're not suspended or just disbarred? When can they do that kind of thing? They can be done if cases can be handled if they're undertaken in association with a lawyer who is admitted to practice in the jurisdiction and who actively participates in the matter. So if you have local counsel, and local counsel is not a rubber stamp, that local counsel is actually, assisting in a matter, actively participating in the handling of the client's issues, then there's a safe harbor for an out-of-state attorney to temporarily come in and assist in the case. Now, this cannot be a situation where the attorney is just signing off on things as local counsel and not really involved in the handling of the case. This is a situation where the attorney has to be actively involved. But that attorney that's local counsel doesn't necessarily have to be at every meeting, doesn't have to be involved in every decision. There has to be a general acknowledgement that that attorney is versed in everything that happens in the case, but not specifically involved in every particular event. Active involvement means that the attorney is generally aware of what's going on and working through the issues with the out-of-state attorney. So that's the first safe harbor, local counsel. Second one is when the matter, the services that are being provided are reasonably related to a pending or potential proceeding before a tribunal in this or another jurisdiction, if the lawyer or the person the lawyer is assisting is authorized by law to appear in such proceeding or reasonably expects to be authorized. Wow, that's a mouthful. There's a lot there. There's a lot of terms and a lot of language contained in that safe harbor. Let's try to break that down a little bit. This is a safe harbor that allows attorneys to handle legal issues, to provide some legal services in anticipation of receiving authorization to handle the work. If I'm an attorney from Minnesota and I'm coming to Illinois to handle a legal matter where I have filed a pro hoc vice petition, which I expect to be granted. There's nothing in my background that would prohibit me from being admitted on a pro hoc vice basis in a particular case. Then the workup of that case is still possible. So let's say it's a personal injury case that has not yet been filed. What can I do? Can I send demand letters? Can I work up the file in anticipation of being admitted? Yes, I can. The preliminary work is okay. It's even okay if I'm the associate of the attorney who doesn't expect to be admitted pro hoc vice, but I'm going to be handling some of the research or some of the letter writing or some of the work on the pleadings for the attorney that's actually going to be admitted. In those cases, it's allowed, it's permitted on a temporary or limited basis for the legal work to be performed. There's a safe harbor for performing that kind of work. Another nuance to that kind of situation might be I have filed my petition for reciprocal admission with the Board of Bar Admissions in the state of Illinois, and there's no reason why it shouldn't be granted. It's pretty clear that I meet all the qualifications in the petition. Can I work up a case in the meantime? Can I do some preliminary work on that case? Yes. It's not prohibited on a temporary or limited basis for you to do that while that petition is being approved. Okay, so that's the second safe harbor. The third safe harbor that allows temporary or limited practice where an out-of-state attorney has not been disbarred or suspended in any other jurisdiction is where the services are in or reasonably related to a pending or potential arbitration, mediation, or other alternative dispute resolution proceeding in this or another jurisdiction. If the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice, and are not services for which the forum requires pro hoc vice admission. Okay, that's again a lot of wordage. What are we talking about? We're talking about ADR matters where an attorney is coming in from out of state and they just want to handle this ADR matter. They want to handle an arbitration before the American Arbitration Association in Illinois, even though they're not admitted in Illinois. As long as the AAA doesn't require pro hoc vice admission and the matter arises out of or is reasonably related to the attorney's practice in their home jurisdiction, then it's okay. This happens when a contract is signed between individuals in another state and provides for, mediation in Illinois or arbitration in Illinois. Well, even though the contract was signed by parties elsewhere, the contract has a provision that requires the arbitration or mediation in our state. And as long as there's no requirement for pro hoc vice admission, then an out-of-state attorney can come in and handle that type of ADR matter without worrying about getting charged with the unauthorized practice of law. So there's also a fourth kind of catch-all provision that allows for a safe harbor, which says that when the services are not within paragraphs C2 or C3 and arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice, then it's okay to handle the matter on a temporary or limited basis. In trying to come up with an example for you of this kind of situation, the first thing that came to mind for me was where an attorney is practicing say, probate law in Florida, and part of the probate estate that needs to be distributed is real estate that's located in Illinois. Can an attorney come to Illinois and handle the real estate closing in Illinois? The matter arose in Florida. The decedent was located in Florida. The estate is being probated in Florida, but there's property in Illinois. Yes, this is a safe harbor that allows for an attorney to do that kind of work. So just summarizing 5.5C, we're talking about a safe harbor for local counsel, a safe harbor for reasonable anticipation of being admitted, safe harbor for ADR matters where the matter arose in the home state and don't require pro hoc vice, and those catch-all matters that relate to the home state matter, home state work of the attorney. If any of those are the case, then it's okay. The safe harbor in 5.5C allows the attorney to engage in that kind of practice. Now, the last section or portion of 5.5 that we said we would talk about today, sorry, I skipped a slide there, is the portion that applies to 5.5D and E. 5.5D and E are the provisions that allow U.S. and foreign attorneys to act primarily as house counsel to practice in a limited manner in a state. This rule also has many subparts, but what we're talking about here is, the provision that allows attorneys to work exclusively for an organization, a company, an entity as house counsel. In this situation, the attorneys are allowed to establish a continuous and systematic presence, unlike the general admission type work, for the representation of that entity. I'm going to be house counsel for Motorola, and Motorola has headquarters in Illinois. Even though I'm not licensed in Illinois, I can practice law as house counsel in Illinois exclusively for the entity. What I cannot do is I cannot represent individuals. I can't hold myself out as available to represent, employees and their children in a criminal charge, DUI, trespassing charge. I can't handle the real estate closing for the employees of the company because, I'm an attorney generally. No, this is work exclusively handled for the entity itself. So I can handle the lease work of the rents to be paid by the company for buildings that they're operating within the jurisdiction. I can negotiate contracts on behalf of my employer entity or company, but I can't do individual work for people generally. What you're seeing now is the language of 5.5D on the screen there. 5.5D says that you may provide services through an officer's systematic presence if you're doing it exclusively for an entity or company as house counsel. This even allows foreign attorneys that are licensed in another nation, to practice in this manner. Foreign attorneys can come in and act as house counsel. They often do for multinational corporations. This is not uncommon, but there are some qualifications. There are a couple subparagraphs that apply to these situations. The services under subparagraph 1 have to be, for the organization or its affiliates, and not be services that require pro hoc vice admission. When the services are being offered relating to a legal issue that pertains to the state or U.S. jurisdiction where the attorney is practicing, there has to be a U.S. attorney involved in giving the advice. The services have to be vetted through an attorney that knows about the issues. There has to be some competence. We can't just let a German attorney advise the company on legal issues related to Illinois if the person is practicing in Illinois as house counsel. There has to be an Illinois lawyer who is duly licensed and authorized in Illinois that helps to vet those issues. So, yes, an attorney can engage in the practice of law for an employer or its organizational affiliates as house counsel, but when there's a state issue, a U.S. issue involved, there has to be a lawyer that knows about those issues, that has competence in those issues to provide the advice. There is another provision of 5.5D that allows for more general services. So if the services are authorized by federal law or state law, rule, or regulation, then it's not the unauthorized practice of law for a lawyer to engage in those services. What is this talking about? It's talking about a lot of different things. Unemployment cases involve what would seem to be the practice of law, representing somebody in a claim for unemployment payments in a state jurisdiction. Some jurisdictions relax the rules on unemployment proceedings before a tribunal. They allow representation by somebody, even though that person is not an attorney. In those cases, the attorney from another jurisdiction wouldn't engage in the unauthorized practice of law by doing that kind of work. Similarly, administrative child protective proceedings. When a child protective investigator indicates a report for neglect or abuse of a child against an individual, in Illinois anyway, there's a regulation, an administrative rule that allows for non-attorneys, even friends, to appear on behalf of the person that was the subject of the indicated report. In those circumstances, an out-of-state attorney would be allowed to step into the shoes of the non-attorney that was permitted to handle those cases. It would not be the unauthorized practice of law for an attorney to do so. What's an example of a federal provision that allows for the practice of law in a state jurisdiction that might be otherwise prohibited? Sperry versus Florida case, a U.S. Supreme Court case, enumerates that kind of situation. I have it on a slide moving forward, but I might as well mention it now. 5.5D2 is a nod to that case. So patent agents are practicing law by doing patent work. The federal rule, however, the U.S. Patent and Trademark Act, that authorizes non-attorneys to do patent work, trumps any state rule that says it would be the unauthorized practice of law to engage in that kind of conduct. So just so you understand, non-attorneys are authorized to do certain things, even though it might be the practice of law in various jurisdictions. Well, attorneys from out of state can also handle those kinds of services if there's a rule that permits it. So that would be 5.5D. All right, here's the slide that I was referencing. We've already covered that as far as Sperry versus Florida. I'm going to leave that to people to explore further if they're interested. Let's move forward to 5.5E. 5.5E is the rule, the portion of 5.5 that further clarifies the implications of 5.5D. So in order for an attorney to be eligible as a foreign attorney to practice under 5.5D as house counsel, the foreign lawyer must be a member in good standing of a recognized legal profession in their home jurisdiction. If you're not in good standing in your home jurisdiction, then you're not eligible to practice under 5.5D as a foreign attorney acting as house counsel. The rule even goes further. 5.5E says that if you have engaged in misconduct as an attorney in your home nation, there has to be a mechanism for removing your authorization to practice. There has to be an ability by your home regulation to suspend or disbar you before the profession in that nation before you're eligible to practice in a United States jurisdiction. So let me try and give you a concrete example of that. You're working as an attorney, you're authorized as an attorney in your home nation, which is a third world country in Africa. And your third world country does not have the ability to revoke, they don't have a mechanism to revoke your authorization to practice. There's no disbarment procedure in your home nation. If that's the case, then you're not eligible to practice as house counsel under 5.5D in a United States jurisdiction. I think that's pretty self-explanatory, but the other requirement of practicing as house counsel in a United States jurisdiction is that many U.S. jurisdictions, I would venture to say most, have some form of house counsel rule. So if it's required in a particular jurisdiction for you to register as house counsel, then you have to do that in order to be eligible under 5.5D to practice. What I'm talking about is contained in 5.5E2. 5.5E2 says that in order for you to be authorized to practice, as house counsel, then you need to have registered under a rule that's required by the highest court of the jurisdiction in which you're attempting to practice as house counsel. If there's a house counsel registration rule in the state, you need to abide by it. So before I end today, I just want to talk about some proposed changes to 5.5. In 2022, the Association of Professional Responsibility Lawyers, which is the body of attorneys that defends lawyers in charges of misconduct. It's the Bar Association for Respondents Counsel in disciplinary matters. It issued a report recommending changes to 5.5. They recommended that 5.5 be amended to allow lawyers to practice in any jurisdiction, so long as they're not misleading people and they're disclosing their jurisdictions of licensure to the people that they're representing. I venture to say that there's been some strong objection, particularly among the attorneys of the National Organization of Bar Counsel or disciplinary attorneys around the country to this kind of change, and it has yet to pass. There was a response by the American Bar Association itself to the proposal issued by April, APRL, and that response listed the objections of various organizations or support from various organizations around the country. That can be found on the ABA's website. So if you're looking for, this type of study, what was the ABA response? You can find it on the ABA website. To date, there has not been a consensus for changes of this type to Rule 5.5. There's a need for clarity as to the rules. It's clear that this rule contains some vague concepts. What's temporary and limited? How much can an attorney do? How far can the rule go? The rule needs some modification. There has to be some clarification, some codification of the findings of precedent around the country. That has yet to happen either, but I do anticipate that there will be some modification to 5.5 moving forward. Time will tell. I also indicated that I would touch briefly on the implications for AI. So before I conclude, I think it's important to do that. Artificial intelligence is going to affect the way we administer 5.5 moving forward. In the context of UPL and 5.5, AI could dramatically change the landscape of what is considered unauthorized practice. People can read a prompt into a vocal or audio tool and get a product generated for them through AI. Is the preparation of that document the unauthorized practice of law per se when done by non-attorneys? No. It's pretty clear that it's the application of an algorithm, that's generating certain results, and ultimately, whatever product is generated is the responsibility of the individual that's submitting it. But, I do think that this produces some, difficulty for attorneys moving forward. If we think about the consequences for a lawyer who advises a person about how to frame the computer command that's given to ChatGPT, for somebody who resides out of state in a jurisdiction where the lawyer is not licensed to practice, then the lawyer is giving legal advice as to how to proceed. If the lawyer is assisting with the prompt, or giving the person the context of the command to input in order to get a product generated, the attorney could be engaging in the practice of law moving forward. None of that has been decided by case law. Each state is going to vet those circumstances on a fact-specific ad hoc basis, and we'll see how those things turn out. But I do think artificial intelligence is going to change the world, and it's going to change the way we look at 5.5 and how it's charged. The drafting of a pleading, the preparation of a contract, the drafting of a will, all of those things are going to be feasible for people who have no training. It's a question of what product is generated, what the command is that results in the product, and who vets the ultimate end product of the documents that are prepared. So, all of those things will affect how we deal with UPL moving forward. But before I conclude today, I just wanted to give you some of the best sources to look at if you're a new attorney and you're looking at an issue that relates to the unauthorized practice of law. The ABA model rules give you a survey of the cases that have been decided nationwide on each particular provision in the model rules. That's one of the best sources that's out there. There are podcasts on the ABA website with noted experts. I've actually been the narrator for some of those and hosted expert guests on particular provisions in the model rules. That's on the contents page for the ABA model rules. There's one that pertains specifically to 5.5 with a noted expert from Michigan, Mark Armitage. I would submit that would be a great source to look at if you have 5.5 issues. We have Illinois State Bar Association opinions in my state that deal with 5.5, and the Association of Corporate Counsel has a guide to multi-jurisdictional practice, which is an excellent source when we're talking about 5.5 issues. So with that, I think I've concluded my discussion. I appreciate you listening and taking the time. And on behalf of Justia, thank you for your participation today.
Thank you so much, Scott. Now we do have some questions already in the chat, so I will go ahead and stop sharing and then we can discuss this together. Thank you for being here today, Scott.
Thank you for having me. So I'll just jump right in. The first question, I'm just going to read it. It asks, what if you live in a state in which you are not licensed by that state's bar, but you're admitted in a federal district court in that state? Can you handle matters that have state claims that are included in the federal action on the basis that they are pendent claims? I don't want to tell you that I'm an expert in every state's laws, so let me just preface the answer with that statement. But I should tell you that, generally when you're handling state claims, whether they're pendent to the federal action or not, you're probably engaged in the unauthorized practice of law. You're admitted to practice in the federal court action. Now, there may be claims that are being adjudicated in the federal court. And if that's the case, it's up to the federal jurisdiction to enforce the UPL rules. But if there are issues that are adjacent to the federal case that you're handling, and those matters were governed by the state's laws, then you generally should not be handling those claims. That would be the unauthorized practice of law to do so. So I think I answered that. I'm not positive, but I think that's the best answer I could give with the information provided. The second question asks, I would like to know if I understood well, if an attorney is licensed in New York, but he wants to practice a federal law in another state, does he need to apply for another authorization to do that? I'm kind of changing some things that looked like typos, but yes, if an attorney is licensed in New York and he wants to practice law in a federal jurisdiction in another state, that attorney would need admission to the federal jurisdiction in that other state. Those federal admission rules vary by federal court jurisdiction. So you would have to know the requirements of the federal jurisdiction for which you're trying to apply or handle a matter in. It's not totally clear from the question, but my general answer is that yes, you would need admission in the federal jurisdiction where you're seeking to handle a matter. If you're complying with that federal court's rules as to admission, then you're allowed to handle the matter. The next question asks, what about the California Unemployment Insurance Appeals Board, which permits non-attorneys, for example, labor relation consultants, to represent corporate clients in the matter? That is a frequent practice. I think during the presentation I did cover this, but there are certain matters where 5.5 allows out-of-state attorneys to handle matters in another jurisdiction where they're not authorized to handle matters otherwise. So, where the state rules or the state regulations allow for somebody to handle an unemployment matter, then it doesn't matter that the out-of-state attorney isn't licensed in the jurisdiction. The out-of-state attorney could step into the shoes of a non-attorney who's authorized to handle such matters. The one proviso I would give in answering that question is, please do not hold yourself out as an attorney in the state where you're handling the unemployment matter. So California was the jurisdiction listed. If I'm the Illinois attorney and I'm handling an unemployment matter before the appeals board in California, I should not say that I'm an attorney on behalf of the client. I should not just generally hold myself out as an attorney when handling those matters. If there's a pro hac vice mechanism, you could certainly say, that you're an Illinois attorney applying for pro hac vice to represent the California client before the California Unemployment Insurance Appeals Board. But if I'm just the friend from Illinois, even though I'm an attorney, I should make it clear what my qualifications are. If the limitations of my licensure are Illinois, I might say I'm an Illinois attorney. I'm not licensed in California, but I'm here to assist this person with the California Unemployment Insurance Appeals Board claim. I think that's the best advice I could give. Again, I'm not a California attorney. I don't want to tell you that I know California laws or California unemployment rules. Even the unauthorized practice of law could be interpreted differently in that state. So you should know the law of the jurisdiction which you're practicing or seek advice on that issue. The following question reads, would 5.5a be applicable to an attorney who doesn't review their work after a generative AI helps with the legal writing? 5.5a applies to the conduct of the lawyer. So, if a lawyer is licensed to practice in a jurisdiction, it doesn't matter that that lawyer used generative AI to produce a result. The lawyer is responsible for the work. If you're an out-of-state attorney or you're practicing law in a jurisdiction where you're not authorized, your use of generative AI might amount to the unauthorized practice. So again, it's the lawyer's conduct that matters and the lawyer's authority to practice. So if a lawyer is authorized to practice in a jurisdiction, the AI doesn't matter. But if the lawyer isn't authorized to practice law in a jurisdiction, they certainly could be charged with the unauthorized practice of law for using AI to assist somebody in that jurisdiction. The next question asks, how does the second part of 5.5a relate to states with LP or LLP programs? I'm not totally clear on what you're referring to here. I think you may be referring to limited practice technicians, such as Washington's triple LTs, limited license technicians in the state of Washington, which the program has been discontinued. But if that's what you're referring to, and you're talking about assisting others in doing so, the rules of the jurisdiction control. So in the Washington example, lawyers were allowed to work with triple LTs to make sure that matters got resolved. Again, it would be dependent on the jurisdiction. I'm not quite clear what the question is asking, so I don't want to venture further into analyzing that type of situation. Next question asks, so if I'm licensed in Missouri with offices in Kansas City, Missouri, can I have an office in Kansas City, Kansas, to accommodate clients who live there but have legal matters for Missouri? I mentioned in the presentation that Missouri's rules are a little tricky when it comes to physical presence and the authorization to practice law. I think what your question is asking is what are Kansas's rules with respect to the unauthorized practice of law? And I don't specifically know the answer to that question. You need to be very careful that you've consulted somebody in Kansas who's versed in the unauthorized practice of law and their version of 5.5 to know whether or not it would be a problem for you to do that. I don't think so, but again, I'm not an expert. That wouldn't be my area of expertise. So I would seek advice from somebody in Kansas that could answer that better. The next question, I think it's the final question, asks, this might be an interesting hypothetical on this point. A national corporation has a set of employee benefit plans and employee termination processes. HQ is in my state. Employment law varies between states some, but fundamentally similar. Many people are fired by this company every month. Can I advertise on my website that I give employment advice in 1-hour paid consultations? I do tell prospective clients that I'm only admitted in my state. Even with the disclaimer, you might be engaged in the unauthorized practice of law by giving advice about jurisdictions where you're not licensed. So I would be careful with that. Yes, it's helpful to disclaim to people where you are licensed and that your knowledge is limited to your state's facts, but attorneys give that admonition and then they go further. They give the admonition and then they give advice on another state's laws. I don't think it's wise to do that. This would be dependent on the laws of the jurisdiction where it's occurring, but I don't think in general it's a good idea to give advice to people when you're not authorized to practice in a particular jurisdiction. So I think that answers all the questions. Nina, am I correct? Is there anything else in the queue?
There is one more question. It's from Paul. I can read it if you aren't able to see it on your end.
Sure, I see it now.
Okay.
The question asks, can a private practice attorney, not house counsel, representing multiple business clients, help that client negotiate and close contracts outside the states in which that attorney is licensed? For example, purchasing a business in the foreign jurisdiction, or contracting for the client to perform services in the foreign jurisdiction. Difficult question. So, if we're talking about, you use the term foreign, if we're talking about other state jurisdictions, there are safe harbors that would allow for temporary or limited practice, particularly if there's local counsel. I don't think as a private practice attorney that you would want to give advice on another state's laws. I think that might be overstepping. Again, it's dependent on the jurisdiction where it's occurring and the laws of that jurisdiction. There are temporary or limited practice exceptions, but I don't want to give you an exact answer to this question, not knowing more facts.
Well, thank you so much, Scott, for sharing all of your insights with us and answering our audience questions live today. We really appreciate you being here, and thank you for your presentation as a whole. And thank you all so much for submitting your questions. We want to thank you for joining us for another Justia webinar. Before you go, don't forget that upgrading to Justia Connect Pro gives you access to CLE credit opportunities through select live and on-demand webinars just like this one, helping you stay both informed and compliant. Plus, Pro members get an enhanced directory profile and access to our AI-powered Justia chat to capture even more leads, as well as exclusive discounts on our Justia marketing solutions. To learn more or upgrade today, you can go to pro.justia.com. To have a wonderful rest of your day. Thank you all so much for your time. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.